Hello, we're delighted to welcome everyone to this unusual format for our Daynard Community Lecture. While we only have a few people in person in this room, we have over 80 people who are signed up to participate via Zoom. So, James, let me turn it over to Dean Hackney.
Great, thanks. Good afternoon and welcome to the Fall 2020 Daynard Community Lecture. Twice a year, the Daynard Distinguished Visiting Fellows Program brings nationally recognized public interest leaders to campus. These public interest leaders serve as role models for students, demonstrating how legal skills can be used effectively and creatively to make the world a better place. The fellows each deliver an address that focuses on the strategic use of law to promote public interest goals. Participate in a roundtable with other prominent public interest advocates, visit classes, consult about professional opportunities for students and graduates, and meet individually with interested faculty, administrators, and students. It's my pleasure to introduce our Fall 2020 Daynard Public Interest Visiting Fellow, Attorney Emma Ketteringham, Northeastern University School of Law, class of 1998. Emma started at the Bronx Defenders as a criminal defense attorney and is now managing attorney of the organization's family defense practice. She supervises attorneys, social workers, and parent advocates who represents parents accused of child abuse and neglect and facing possible termination of parental rights. Emma participates in numerous court-based and independent coalitions to develop pro-family policies and practices in New York City, including the committee devoted to reducing racial disparities in foster care. Previously, Emma served as the Director of Legal Advocacy for the National Advocates for Pregnant Women, where she was counsel and strategist on criminal and civil child welfare cases at the intersection of the wars on women and drugs. She also worked as a litigation associate at Lansner and Kubitschek, where she represented parents and children in civil rights actions in state and federal court, and at Paul Weiss, Rifkind, Wharton, and Garrison, where she worked on complex civil litigation. After graduating from Northeastern, she clerked first in the U.S. District Court for the District of Maine, and then at the U.S. Court of Appeals for the Second Circuit. She holds a BA in political science from Trinity College. The policing of families of color, especially Black, Latinx, and Native American poor families, through the family regulation system has often been an underexamined aspect of systemic racism. And yet, in the time of pandemic, glimpses of this system have begun to receive some attention, including recent examples of students and parents punished for inability to attend school virtually. Northeastern University has recognized the importance of research that examines all aspects of youth and family criminalization through a support of interdisciplinary research on the Cradle to Prison pipeline by the Center for Public Interest Advocacy and Collaboration at Northeastern University, together with the College of Arts, Media, and Design and the Boston Area Research Initiative. We are so incredibly pleased to have Attorney Ketteringham as an expert on family regulation, here to shed light on this system today. Along with today's community lecture, we hope you'll also join Emma and her colleagues for a roundtable discussion entitled Family Defense, an Urgent Call to Action, this Wednesday, September 23rd at 12:15. And now I turn it over to our Daynard Distinguished Fellow, Emma Ketteringham, for her talk entitled An Introduction to the Family Regulation System, a largely unexamined part of the Carceral State. Emma?
Thank you so much. It's a huge privilege to be here, and I want to thank all of you for participating. This is a big honor for me, and I'm just sorry that we're not in physical space together. But really thank you to all of you for coming, and thank you to everyone who made this event possible today. I'm compelled to start with a slight content warning. As a family defender, I represent people charged with allegations of child abuse and neglect. And I'm going to start with sharing the experiences of two of my clients, Shanique and Leanne, who are both Black women. And this may be triggering and upsetting for some of you because of the content or because of the overwhelming systemic oppression that will be described. And I want to say that during these particularly heavy times, I'm mindful that today I am adding more heaviness. And I don't share these stories with you gratuitously or as a way to raise my own work. I share them with Shanique and Leanne's express permission in order to best demonstrate the anti-Black oppression of the family regulation system. And I do so today because I think it is important to not turn away or retreat from the violence of these systems, because we need to interrogate them. I also want to acknowledge that I'm a white professional woman who has never been personally oppressed by the system I will describe today. I know that the fact that I have this platform today, rather than Shanique and Leanne and those who have been oppressed by the system directly, is due to the same white supremacy that upholds the system I criticize today. I'm aware that colonizing is an ongoing process, and it's reflected in the fact that it's me here today before you, rather than those parents who have survived the system. My intent today is to honor the strength and the struggle of Shanique and Leanne and their families, and to further this important conversation. I also will try to be intentional about language. The term family regulation system might not be something that you've heard before. That's because this is a system that's better known as the child welfare or child protection system. But as Dorothy Roberts, a reproductive justice scholar, explained, if an outsider looked at the American child welfare system, she would likely conclude that it is not a system designed to promote the welfare of America's children. Rather, it is a system designed to regulate, monitor, and punish poor families, especially poor Black families. So in June of this year, she published an op-ed about how this system deserved the same attention as the criminal legal system was getting. And she encouraged us to be more intentional in our language. So that's where the term family regulation system originates, and I'll attempt to use that here. Shanique. Shanique is the mother of 5 children. Her children range in age from 2 to 19. And she and her family have lived in the South Bronx their entire life. Her neighborhood is the target of violent and invasive over-policing. And one fall day, after her older children had left for school, Shanique was home with her 2-year-old daughter, Kayla. They were quietly playing a game on Shanique's phone until her door crashed open. And Shanique and Kayla were surrounded by police, screaming at them to get down. With their guns drawn, the police announced they were there to search the apartment for drugs. Shanique and her family had been caught up in a routine buy and bust operation. During the illegal search of Shanique's home, the police found half of a joint of marijuana in a jacket hanging in the closet that belonged to Shanique's teenaged son. Based on that half joint, Shanique was taken to the precinct and then on to central booking, where she was charged with a felony sale of narcotics. Shanique had not sold drugs to anyone, and the police never had much evidence that she had. No large quantities of drugs, no money, no scales, no paraphernalia were recovered from her home. But the police knew that her address, her race, and the small amount of marijuana were enough for an arrest to stick, earn them overtime, and to set the criminal punishment system into motion. Shanique was taken to the precinct, processed, and held for 48 hours. She was given no information about her children, where Kayla had been taken, what had happened to her girls when they returned home to an apartment tossed by the police, and the wait was unbearable. And when she finally saw the judge, the case was adjourned for dismissal in under 2 minutes. What happened to Shanique was unfair, unlawful, and also not unusual in over-policed communities. And I think we can all agree that the deprivation of liberty is a profound deprivation, especially when done as a result of unjustified and abusive police power. But ultimately, Shanique's arrest and even the 2 days in jail turned out to be just the first moment in a painful ordeal for Shanique and her children that lasted almost a year. Because when the NYPD arrested Shanique, they also called the New York State Central Registry, often known as the Child Abuse Hotline in most states, and reported Shanique as a child abuser. And before any family court judge heard her side of the story or learned that her criminal case had been all but dismissed, the Administration for Children's Services, what we call ACS in New York City, took all of her children away. The caseworkers, who lacked social work degrees and training in child development or the trauma of family separation, went to the children's schools, removed them in front of their teachers and friends, and then questioned them in an effort to build a case against Shanique. They asked the children if their mother did drugs, if she sold drugs. That night, the children were taken to separate foster homes in communities far from their own. And the next day, they were brought to attend different schools without their friends. No one brought them to see their mother. They were told only that their mother was in jail. And there began the family's ordeal with the so-called child protection system in New York City, a system that exists ostensibly to protect children, a system that is full of people who claim to have the good intention of saving children. But what is actually an almost perfectly racially segregated system of unbridled discretion, rush to judgment, and little to no due process. A system built by people who would never tolerate its response or its actions for their own families. ACS filed a petition against Shanique, claiming that she was a drug dealer who had sold drugs with her 2-year-old present next to her. They took their information directly from the NYPD paperwork. It didn't matter that the case had been downgraded or dismissed. It didn't matter that the search had been illegal. It didn't matter that the drug found was marijuana, a drug used indiscriminately and publicly by wealthy and white parents. It didn't matter that the half joint was located in a teenager's jacket pocket. The arrest itself was enough for the so-called child protection system to be set into motion. A system where a parent is guilty until proven innocent. A system where children are removed before anything in the petition is proven. A system where the children, not the parent, serves the time in state custody. When Shanique appeared in family court the first day, the judge ordered supervised contact only between her and her children. This meant that Shanique was permitted to visit her children only once a week and under the watchful eye of the caseworker. And she was not permitted to discuss the case with her children. These visits were painful as she struggled not to tell her children the truth. Despite not having a drug problem, Shanique never tested positive for a single drug. Shanique was required to complete a drug treatment program before her children could return home. Despite being a loving parent to healthy and well children, active in her children's schools, a mother to a son with a college scholarship, Shanique was required to do a parenting class that lasted weeks. And despite the fact that Shanique had never harmed her children and that her children were broken without her, her children served 6 months in the foster system before the judge ordered them home, digging a psychic wound so deep it would never truly heal. And had Shanique not been able to complete her program and her classes within the 18 months that the law affords, the state could have moved to terminate her parental rights and adopted her children away. Leanne is a young mother to 2 boys less than 15 months apart. Both boys were born with developmental challenges and are a lot for any mother with all the resources in the world to handle. Leanne is a single mother with no family support and multiple health challenges of her own, for which she is often hospitalized. Her young son was diagnosed with a medical condition when he continued to lose weight. His pediatrician put him on a strict feeding regimen, which required constant attention and care and routine visits to the hospital. But Leanne's own illness and living conditions made preparing the special meals almost impossible. She lived in an apartment that often had no hot water and was overrun with rats. She and her older son were often frightened to enter the kitchen, and she could not keep fresh food in the home. And the relationship between Leanne and the boy's pediatrician was fraught from the beginning. The pediatrician made it clear that she did not think Leanne took her son's condition seriously. The medical records were full of notes that revealed the pediatrician's pure disdain and impatience for Leanne. She would note over and over that she felt Leanne did not appreciate her son's needs. She would even describe Leanne's dress and smell in negative terms. Not once did this healthcare professional ask Leanne what support she needed or what was challenging at home. Instead, Leanne herself was assumed to be the risk to her son. When her son continued to fail to meet the doctor's expectations and Leanne missed a medical appointment, the pediatrician, who had sworn to do no harm, called ACS and reported Leanne as a child abuser. ACS is a multi-billion-dollar agency with hundreds of caseworkers and social workers. Its claimed mission is to keep children safe and improve their well-being. But their approach is steeped in the belief that poverty is a failure of individual will, that child poverty is child neglect, and they are ill-equipped and unwilling to address the decades of racism and inequity that is to blame for the families struggling. The call to ACS did not bring Leanne and her sons the financial support they needed. She wasn't offered a habitable home or assistance in negotiating with the landlord even to fix the conditions in her apartment. No one offered to assist her in applying for the health benefits or home nursing support for which her family qualified. Instead, ACS took Leanne's boys away and gave them to a foster caretaker, and then paid that person thousands of dollars a month to care for Leanne's son and ensure that they got the medical support they needed. And Leanne became a case pending before a judge who had as much righteous white judgment for her as the pediatrician. Leanne's circumstances and isolation were treated as a lack of insight in need of therapeutic rather than economic and supportive intervention. And what was worse is that the intervention itself caused more harm. When ACS took her fragile young boys to the foster system and allowed Leanne to see them only once a week, Leanne grew depressed and her health deteriorated. As Leanne's health challenges grew, the courts and ACS's demands on her also grew, making meeting their demands all the more difficult. And meanwhile, the termination clock ticked. And what of her boys? Her boys were placed with a foster woman who was an angel in the street and a devil at home. That's what Leanne used to call her. The judge loved her, praised her, believed her to be perfect, but the boys appeared at the visits with bruises. They complained that their foster caretaker made them call her mommy, threatened to call the police on them when they misbehaved, and sometimes withheld food. Rather than serve as a temporary loving caretaker for the boys, this person succumbed to her own need to be a savior, undermined Leanne at every turn, and ultimately did more damage to the boys than their mother had ever done. The case became a wrestling match between Leanne and the foster caretaker, again, who was given thousands of dollars each month to take care for the boy, to care for the boys. It was really only when the foster caretaker was caught in a lie about Leanne by the children's therapist that the court finally relented and Leanne's boys came home. Had that not happened, I worry that the boys would never have been returned. More likely, Leanne's rights would have been permanently terminated simply because so much time had gone by, and her boys would have been adopted away, a success in the eyes of this system. Ultimately, although they were finally returned home where they remain today, the boys spent almost 3 years in a foster home with a caretaker who posed greater risk than the home from which they came. Over 500,000 parents and children are ensnared in the foster system in the United States. And the United States is first in the world in terminating parental rights and adopting children away from their parents. This is a system where no matter the initial allegations or reasons that children enter the system, if the parent fails to meet the system's demands in a number of months, the state has authority to dissolve the family, what Brian Stevenson calls the civil death penalty. In this way, all of our cases are potentially capital. What happened in the name of child protection or child welfare to Shanique and Leanne and their families would not happen in a society that values the bonds between Black parents and their children. And what happened to these mothers and to their children and to so many more is why many parents in the Bronx, where our office is located, tell us that they fear the knock on the door by ACS even more than the stop in the street by the NYPD. I started out as a public defender in the criminal legal system many years ago, and it was this understanding that motivated me to enter the little-known practice of family defense. Back in 2005, there were no truly independent, holistic organizations representing parents in child protection proceedings. While children had the benefit of organizations with lawyers and social workers, representation for parents was provided by solo practitioners paid by the hour and who depended on the court for their living. Mothers like Shanique and Leanne had little hope in getting their children back, and I met both of them in the middle of their cases when they reached out for new counsel and after much harm had already been done. For decades, parents were not provided strong, zealous representation, and the court was little more than a rubber stamp on ACS decisions. And as a result, many children needlessly suffered as they languished in the foster system when they could have returned home. Today, the Bronx Defenders is one of 4 organizations in New York City and part of a national movement to improve representation for parents. We have 75 attorneys, social workers, and parent advocates, and we represent the majority of parents in the system in the Bronx, a community which has the largest percentage of children in the foster system in New York City. So what is family defense? And what is the family regulation system? The short answer is that the practice of family defense is the representation of parents and caregivers accused of child abuse or neglect. We are assigned, like defense counsel in a criminal case, to zealously represent the accused. In our cases, the parent is charged with abuse or neglect. Not all parents who are investigated or even filed against actually have their children removed from their care. Our job is really to fight to keep the family together or reunify the family, so long as that is their stated wish. We have a client-centered, holistic model of representation. So we work with defense social workers who are not mandated reporters. That's a difference between New York and Massachusetts. To address what brought the client to the attention of the system and to combat the enmeshed penalties of the system. We assist our clients with accessing what they need most to keep their families intact. For example, we host in our office one of the very first client emergency funds that lives in a public defender office, because so often it is just cash assistance that is the difference between children being removed and children staying home. We also started a legal hotline so that we were there when our clients first needed us, right? If you think about it, people of privilege obtain legal counsel at the first sign of trouble because they can afford to purchase that service. We wanted to make sure that our clients who have to rely on the court to assign them counsel actually had access to a lawyer when they first needed one. So we started what we call our early defense practice. And we advocate by our client's side for the services and resources they identify as necessary for their families. Our practice is very litigation heavy. So we litigate scores of hearings to prevent children from being taken from their homes. We litigate abuse and neglect trials, and we litigate termination of parental rights proceedings. Our cases are complex and often involve the use of experts. There is definitely sort of a tradition of a lot of junk science being used to prosecute our cases, and so we rely heavily on the use of experts in our own litigation. It's worth noting that our proceedings are civil. So despite the importance of the fundamental interest involved, we litigate without the protections provided in criminal cases. The standard is just preponderance of the evidence, not beyond a reasonable doubt. We have no juries, and we have to litigate before judges with all of their, all of their cultural and personal biases. Even a res ipsa cause of action is actually permitted in our cases, and I think many of you are taking evidence right now, but or torts, but yes, that's the barrel case. So in our cases, a parent can be found guilty of abuse if there's an injury, if their child is found to have an injury for which there is no explanation and the child was in their care at the time. So there's just, the state basically has every advantage in these cases. In addition, children's hearsay. So hearsay, possibly of the least reliable citizens in the world, is permitted to be admitted against our clients. So sometimes the way we think about it is that, we litigate cases with just as much of an important interest at stake, but almost with our hands tied behind our back. And of course, we're profoundly under-resourced as compared to the state. So that's kind of a synopsis of the practice and what it's like to be a family defender, and sort of what our work involves. But to fully understand our work and why we see it as really part of an opposition movement, much more than just providing legal services to those who need it. In order to understand why we see it that way, it's important to know who are the families who stand accused in the system, and how does this system operate? The prevailing view, I think held by most people, and myself, honestly, well before I knew, is that the parents and caregivers who are charged with abuse and neglect have done something horrible to a child. That is the presumption. And the correlating belief of that misperception is that the thousands of children in the foster system are there because they're better off there. And they must remain there to be safe. This misperception is fueled, I think, in large part by a media which is full of stories of parents who have abandoned their children or horribly abused them, or stories of where the state did not move quickly enough to save them from their fate at the hands of their parents. The media rarely, if ever, reports the many more stories of children wrongfully removed from their homes and never returned, or of families ensnared wrongfully and unfairly by the system. Even when the media does expose the harm of family separation, as it did when we saw thousands of children forcibly separated from their parents on the US-Mexico border, it fails to connect that harm to the harm that actually is the purpose of the well-funded foster system. Yet it is fact that the vast majority of parents that we represent have not abused, abandoned, or committed an inhumane act against a child. They are charged with neglect, not abuse, meaning they're deemed often to pose some risk, physical or emotional, however attenuated, in some way to their children, rather than having done them serious harm. And across the United States, over 78% of children deemed maltreated have been so due to neglect, not abuse, not to some form of physical or a mental abuse. And not only are most children in the system due to neglect allegations, not abuse, neglect is defined in the law. In every state statute that defines neglect, Neglect is defined as almost synonymous with poverty and a lack of social support. State neglect statutes define child neglect as a failure to provide a minimum degree of care to children. Well, what that minimum degree of care is can turn completely on a judge's own cultural bias, racial bias, and child-rearing beliefs. And studies confirm what we see, that it's poverty or a lack of resources, which is the leading predictor of placement in the foster system. And the amount of time, by the way, that children spend separated from their parents. So one study, for example, shows that children who are below the poverty line are 22 times more likely to be involved in the family regulation system than families with incomes just slightly above it. And a study of lack of supervision cases in New York City. So those are cases where a parent or a caretaker might have left children in the care of someone the state doesn't deem suitable, or maybe even left them home alone at an age that the state does not think is old enough. So these are lack of supervision cases. And in 52% of those cases, the service most needed was childcare, yet what parents were given was foster care. Other studies have found that a large number of families are kept apart solely because they lack decent housing. Yet our country is unwilling to ensure that families are stably housed. Data shows that it's actually lack of access to stable housing and not substance abuse that is the greatest barrier to reunification of families, despite widely held beliefs that is primarily drug-using parents who are in the whose children are in the system. Our clients are not homogenous, but they are invariably low income, and many have faced significant challenges in their lifetime, such as violence, poverty, homelessness, hunger, incarceration, and often time as children in the foster system themselves. Many of them have had their children removed from their homes for unjustifiable reasons, like Shanique, and their cases demonstrate ACS error in removing children from loving and caring homes. And many of them have cases where the facts are not necessarily in dispute, but they live in circumstances like Leanne's, which are the result of decades of race and class oppression. They deserve support, reparation, and compassion, not accusation or surveillance. Many are caught in the system because of allegations that they failed to protect their children from harm inflicted by someone else, but they've never actually hurt their children themselves. It's their judgment that's put on trial. Others lose their children because maybe they've used or have an addiction to a drug our society has deemed illegal, or they might have symptoms of mental illness or suffer from a disability, cognitive or physical. All pathologies and issues experienced by privileged people who are able to address their problems with private resources. Save for a very tiny few, they are also parents who love their children, who care and wish for a better future, and who cherish their identity as parents. Just like all other parents, they have aspirations, complex emotions, poor luck, better luck, lapses in judgment, moments of shame, and sometimes self-destructive impulses. But rarely are they judged with the benefit of context and circumstance as privileged parents are when they're challenged or when they err. Even those of our clients who choose to be, or maybe cannot be, the primary caretaker for their children, this system seeks to erase them legally and emotionally, rather than have them play some role in their children's lives. And in child protection or family regulation proceedings, parents face the loss of one of the most precious things in their lives, their children. So while the world presumes that the families caught up in this system involve parents who've done harm to their children, that is not what we see. The system reflects the economic inequality and the relative poverty we allow families to endure in this country. And it's not just poor families who are overrepresented in the child protection system. Just like the prison and deportation systems, the foster system suffers from extraordinary racial disproportionality and disparity and is not applied equally to all families. New York City's family regulation system is one of the most racially segregated systems in America. To walk into a family court in New York City leaves one with the impression that white parents never make mistakes, never use drugs, never have mental health issues, and never make a mistake. And that's not surprising, given that the intervention of the foster system, taking children from their families of origin and placing them in other homes deemed more suitable, has its inception in racist and classist beliefs. The foster system was the imagining of white Protestant reformers who were terrified of the immigration families relocating to American urban centers in the 19th century. They purposely, with racist intent, devised a system whereby the children of recent immigrants would be taken away and raised by more privileged, more suitable white parents. The separation of children from Black parents is also understood as part of our nation's shameful history of separating children from Black people when they were enslaved. Our country has always provided less protection for those bonds. And because at its essence, the system really is part of this nation's history of sorting people into suitable and unsuitable categories. And the idea of who is suitable is infused with white supremacy that has always deemed classes of people, marginalized people, as unsuitable to bear, beget, and raise children. And the current system reflects and reinforces these origins. For decades, Black children have made up the majority of children in the United States family regulation system, despite making up a relatively small portion of the nation's population. Most recent New York State data available shows that Black children are 5 times more likely than white children to be investigated, 7 times more likely to have their cases indicated, meaning their parents' names are placed on a registry of people who have maltreated a children, and their employment is limited by virtue of being on that list. And then 14 times more likely to be placed in the foster system than similarly situated white children. Data from New York City is even more telling. That was New York State data. Data from New York City shows that in 2018, ACS removed an average of 230 children a month from their homes. 97% of those children were non-white, 97%. A common explanation from ACS for the racial disproportionality in the system is that, well, it's society that's racist. Because the mandated reporters, the people calling ACS on families, they're more likely to report Black and brown children to authorities. Well, no doubt that's true, right? Studies of pediatric ERs certainly show that hospitals are much more likely to call child protection for Black kids with the same medical findings as white kids. And we also know that Black women are 10 times more likely to be drug tested without their consent when they give birth than are white women, despite the fact that actually rates of illegal drug use during pregnancy are actually more prevalent among white women. This is a common entryway for babies of color into the foster system. So these racial disparities in drug testing are definitely a way that there's a disproportionate number of Black and brown kids entering the system. But that doesn't explain why race disparities increase even once children are in the system. Because it is fact that Black children are more likely than white children to be placed in the foster system, even when they have the same characteristics as white children. That means that white children are more often left in their homes with family prevention services put in place, whereas Black children are taken out. And a recent study, this is very recent, it was last year, of race-blind removals showed that when details that could identify the race of the child are removed from the report, disparities in which children, the race disparities in which children are removed drastically decrease. And once in the foster system, Black children suffer worse consequences. They remain in the system longer, they're moved from home to home more often, they receive fewer reunification services, and they receive less desirable placements than white children. And they're more likely to never be reunited with their families, and they're the least likely to be adopted. So although the stated intention of the family regulation system may not be to dissolve poor families of color, the families who are most surveilled and most often dismantled are poor and disproportionately non-white. Every day, by demanding due process for our clients, by defending families, and by fighting the state in these cases, we are resisting the state's violent and unnecessary dissolution of Black and brown families. And then, of course, what of the children? Strong family defense for parents not only benefits our individual clients, the parents, but we believe strongly that it also benefits their children. By defending parents and strengthening families, we prevent the traumatic removals and poor life opportunities that too often are guaranteed by the foster system. Now, that is not to say that all children raised in the foster system or adopted from the system are doomed. Of course not. But to say that being raised by the state or even to be adopted is challenging is an understatement. It's impossible to measure the benefits that the sense of belonging to a family provides, even to a family with adversity, challenge, and risk. And it's easy to see that the state does not make a better parent overall, despite individual triumphs of many children. Studies in jurisdiction after jurisdiction have found that rates of safety are worse for children in the foster system than for those in family preservation programs. One study showed actually that children are twice as likely to die of abuse in foster care than in the general population. And New York State, which has a very well-funded foster system, actually ranks the third worst for rates of maltreatment of children in foster care. And the many children who age out of the system at 18 experience a higher risk of negative life outcomes, including lower career earnings and being disproportionately likely to experience homelessness and a lack of mental health care or support. One national study found that about 1 in 5 foster youth will become homeless after age 18, and 1 in 4 will spend time behind bars less than 2 years after aging out of care. So not only do the very interventions of the system actually cause harm, its existence means that society ignores and fails to fund solutions for the problems posing harm to the children in our community. And what I mean by this is that by perpetuating the view that it is poor, specifically Black, parents, those individuals who pose the greatest risk to their own children, we fail to protect the children for whom we purport to care so much. That's because the approach of removing children from all they know, often from all they love, and dismantling their family, that does nothing to address the material disadvantages of poverty, does nothing to challenge the racism, the decades of racism in this country, does nothing to empower communities, fix failing schools, end police violence, make our neighborhoods safer, provide safe housing and opportunity, or clean our air and water. All things that do exist and actually threaten extraordinary harm to the children of the Bronx. I mean, in this way, the system is very similar to the criminal legal system in that it is a way of punishing people or acting or laying the blame at the feet of individuals and then punishing them for what our society refuses to take responsibility for. In fact, and we know, of course, that this approach of acting as if it is an individual failure rather than societal failure for what makes families struggle does nothing to instill hope in the hearts of struggling parents for their children and for their futures. In fact, what we found is that involvement in the foster system leaves parents worse off than they were before. this sort of central focus on personal transformation without equal attention to material conditions almost always makes things worse for families regulated by the state. We see parents who lose their job because they're now being asked to attend therapeutic interventions and classes and services and attend court. So we see parents losing their job just by virtue of having contact with the system. We've seen parents, lose their housing because so often social welfare programs and even income is tied to your family composition. So if your children are removed from your care, you may end up more vulnerable. And then you lose your home, and then you can't have your children returned to you until you regain a home. So it's all sort of extraordinarily destabilizing for families to even have contact with the system. So rarely are families left better off for having had a case or for having had contact with the system. And I think it's self-evident, right, that loving and raising one's children is really at the center of our humanity and of our identity as humans. It's one of the most basic human rights. It's how we pass on language and culture and heritage. And raising children allows us to understand our past, and it also allows us to look far into the future. And a family regulation system that indiscriminately and unfairly interferes with this right due to conditions primarily caused by centuries of racism and economic inequity does deep damage, not just to individuals, but to entire communities. And so that is why, as we rise up and we demand the defunding of the police and carceral systems, as we insist that the wealth and the power that has been put into these state carceral systems be transferred back to communities and be given to communities so that communities can reimagine the support that they need to raise healthy families. As we look to transfer the power from systems that surveil and punish and destroy communities, we have to be mindful that the family regulation system is sustained by the very same white supremacy, the very same inhumanity, and the very same efforts to colonize communities as the carceral systems we know well. And that is where I was planning on actually ending my remarks, but I realized that it is a little bit earlier than we thought. I think I maybe spoke too quickly. But I would be happy to open up for questions or to more of a dialogue with everyone here. I'm not sure how to make that happen, but thank you for listening.